And finally, I give you the case of Williams. It's tab 28. And this, I believe, Justice Rothstein addresses your concern and your question to me with respect to the temporal connection. This case says that at page 3, paragraph 40, exigent circumstances are where there are real, immediate, and serious consequences would certainly occur if the police officer postpones actions. The test has two subheadings. First, there's a temporal requirement. Second, there's a consideration of the gravity of consequence. In this case, under those two subheadings, A, there was no threat in Clayton. B, there was no gravity of consequences. The caller does not indicate that the guns were used to further the commission of a violent offense or suspects in any way threatened to use the weapons now or in the immediate future. Given that and given the balancing with respect to when charter rights can be suspended or how they ought to be dealt with, in this case there was no reasonable necessity to cast aside charter rights because of the lack of urgency to preserve public safety. I'm going to give you two examples of exigent circumstances, and I have given you a number as I've reviewed these cases. In Crippen, that's Defense, Our Authorities, Farmers Authorities, Volume 1, Tab 9, this is the rocket launcher case, and I've already gone over the facts about the warrant. The court said the unconventional weapon, the speed of deployment, and risks created in exigency which permitted police to circumvent compliance with the knock and announce rules. So again, it's fact-driven. I've given you authority for the facts that firearms in and of themselves, yes, they're inherently dangerous. Yes, there's always a public safety concern issued associated with firearms.
It seems to me, these cases describe a very different society. Much higher tolerance for weapons generally. One would recognize here.
In a way, the United States citizens have protection to the right to bear arms, and there is a very high standard, and the home
high
is...
tolerance of arms.
I agree with that comment, Justice Binney. However, the high tolerance is not with respect to illegal firearms, and I think the case law is quite clear, regardless of whether it's Canada or the United States, the presence of illegal firearms is a serious matter to be taken into consideration.
But you don't... Sorry.
Legal or illegal, I mean, it depends on the circumstances. It seems to me more than the classification into legal or not. In this case, handguns in a situation where, as has been pointed out, there's no obvious benign purpose to having them. Get into cases of hostages and rocket launchers and so on. It seems quite a remove from what we're talking about.
I'd like to address that comment, Justice Binney. The issue of is a firearm an innocuous object? And the Crown imports the fact that, well, what else could firearms be used for, if not for a dangerous purpose? I can simply say, in reviewing these facts, and it may be in the reasons of Justice Durno with respect to sentencing, that question was blankly asked by myself on sentencing, and the issue is, well, why did Mr. Farmer need to have a firearm? And the defense position to that, and was submitted on sentencing, was there was a homicide of a friend of his involving a firearm. He was concerned for self-preservation, and it was carried for self-defense. So it's not an issue where firearms can be simply there for a nefarious, illegal purpose. There is also the alternative purpose of self-defense, albeit illegal possession, but that might be another scenario to address the issue.
That's a cultural difference. People can run around with firearms for purposes of self-defense. This is, again, describing what may be acceptable south of the border. I'm not sure that we've reached the point that's acceptable here. Case dealing with prisons on that issue. We're now expanding into the broader society. Self-help, self-armed.
Well, Justice Benny, there's a strong line of U.S. authority, and it's contextual, but in my respectful submission, the issues of exigency, the considerations that firearms in and of themselves and their mere presence do not raise the level to exigent circumstances is a fundamental principle, and I think ought to be recognized, and was recognized by Justice Durno in his imminent harm test, that there was no objective foresight of imminent harm. This was not a call about threats. Again, it's fact-specific, and in my respectful submission, the test is mere presence doesn't elevate it. You and I may disagree respectfully on that, but that's the defense position on.
Oh, but when you have the right to bear arms, as they do in the United States, I guess I'm repeating the question, that changes everything. You have the right to bear arms, and therefore it's expected that people will have handguns, and that's so totally different from Canada, where it's illegal. What kind of objective or what kind of purpose can there be other than harm?
Justice Rothstein, it's not a cultural difference. In the United States, the right to bear arms does not extend to the right to bear illegal arms. Just like in Canada, you have a licensing regime, as you do in the United States.
But behind that is the suggestion that the police, when they're being told about a possible emergency, ask the question, are we talking about a legal or an illegal firearm? And I just don't, that's an ex post facto determination that gets made after the event.
I'm not suggesting that at all. I'm just addressing...
I don't know that, I think Justice Benny's right. I don't know that it matters that it turns out to be illegal.
I agree with you, Justice Bella, and I'm not suggesting that at all. The police do not have to turn their minds to the legality of the firearm. They have to turn their minds to objective perceived use of the firearm in the context of a threat, brandishing, other such things. So I'm not saying the mere presence of the firearm in terms of its legality is not being debated by myself. I'm not saying the police have to turn their minds to it. I notice I have 5 minutes. I'd like to summarize and provide you with the other areas that I haven't been able to get to. The second area is that the initial stop was not justified under the roadblock test set out by Justice Doherty. Justice Doherty sets out 3 criteria. There are reasonable grounds to believe that a serious crime has been committed. A. B. The roadblock may apprehend suspects, and most importantly, C. The police must consider less intrusive investigations. At page 71, paragraph 61, Justice Doherty outlines where the police failed in this analysis. It failed at B and C of the test. The police should have used the filter of the information they had to set a roadblock tailored to the known facts. Instead, they chose to ignore it. This was a significant failure. Paragraph 60. This was due to an institutional failure to train the police to respect charter values. Individualized suspicion is still required in gun cases. I refer you to Justice Durno's own decision to Charlie, Volume 1, page 17. And in my respectful submission, the police made selective use of facts. They ignored the vehicle description. They ignored the clothing. They honed in on one racial factor, and this is not a case about race, but the case of selective use of certain descriptors. And finally...
Sorry, I think that's important. Justice Doherty explicitly and firmly rejected that was an issue in this case.
Oh, no, that's what I'm saying. It's not an issue. I'm just saying they used this, one of the descriptors. It could have been anything, but the fact that they chose to focus on one as opposed to the other ones that are related to that, they used selective use of the descriptors. They chose to ignore some and chose to rely on others, and this was unjustified, but not relying on the 911 caller's information. That's what I'm trying to say.
Could you assist me with one thing? Was that argument you're making here made at trial in this sense, that the police, the difficulty was that as I read the dispatch transcript, as they're approaching, they're given evidence that complainants saw approximately 10 parties, 4 of them with guns, and then the description.
No,
was the argument made, I'm just wondering if the evidence was then fleshed out as to what time they had to consult with each other and make a plan as to what cars they would stop, if any, or only these, or was that argument made at trial?
Yes, the argument that was made at trial was selective use, that the police had individualized suspicion and they only chose to rely upon a few factors. The other factors would have excluded Farmer and Clayton. That argument was made.